Article 126 Oath Canon 2253 An oath is a solemn appeal to the divine creator by invocation and the presence of at least two witnesses that a pronouncement is true or a promise binding. Canon 2254 An oath is only a valid oath when it is sworn in recognition of the rights of all men and women as sponsors to persons present within the court, including the spirit of the living law, and includes a pledge to speak honesty before the court. The touching of any object during such swearing is materially irrelevant to the validity of any oath. Canon 2255 The living law is present in a valid court of law when all words are given under oath. When officers of the court do not properly give oath, the living law is absent, even if all parties and witnesses show respect and due process of law. Canon 2256 A man or woman of good standing before the law is any man or woman having sworn an oath before the court, having been found to demonstrate respect for the living law and due process of law. Canon 2257 No one shall be denied the right to swear an oath before a valid court. Canon 2258 An oath extorted by malice, force, or grave fear is null by the law itself. Canon 2259 No one should be heard within a valid court unless they have previously sworn a valid oath for that case. Furthermore, no testimony in written or oral form is valid unless a valid oath has previously been sworn. Canon 2260 The breaking of an oath, especially by any officer of the court, is a most serious offense which must be treated as the gravest of injury to the living law. Article 127 Vow Canon 2261 A vow is a solemn engagement or undertaking made to the divine creator to perform some action, to make some gift or sacrifice in return for special favor. Canon 2262 A vow made free from coercion, fear or deliberate deception must be fulfilled. A vow made out of grave and unjust fear or malice is null by the law itself. Canon 2263 A vow made by oration in the presence of others is always superior to a written vow, or vow made in private, even if recorded. Canon 2264 A vow is solemn if made by oration in the presence of others and if a legitimate superior person accepts it in the name of a valid juridic person. Otherwise it is simple. Canon 2265 By its nature a vow obliges only the person who makes it. Canon 2266 A vow ceases by the lapse of the time designated to fulfill the obligation, by a substantial change of the matter promised, by the absence of a condition on which the vow depends, by the absence of the purpose of the vow, by dispensation, or by commutation. Canon 2267 No temporal force or action nor person can dispense or commute solemn vows of supreme persons. Canon 2268 Only a supreme person can dispense or commute solemn vows of superior persons and all lesser persons. Only a superior person can dispense or commute solemn vows of ordinary persons and all lesser persons. Only an ordinary person can dispense or commute solemn vows of curator persons and all lesser persons. Inferior persons have no rights nor powers to dispense or commute solemn vows. Canon 2269 Excluding a supreme person, simple vows may be dispensed or commuted by any superior person. Canon 2270 As inferior persons have no power nor authority to dispense or commute solemn vows, when any such vow is breached or any action is made to claim that dispensation or commutation is given, then such an action is a direct injury to the divine creator and all law. Therefore any such liability and penalty due immediately befalls the person who breached their solemn vow. Article 128 Covenant Canon 2271 As a particular form of agreement, a covenant is a solemn agreement reduced to writing and duly executed whereby one or more of the parties named therein engages that a named act is already performed or is to be performed sometime in the future. A covenant may also call for the performance or non-performance of some specific duty and may constitute an agreement to do or not to do a particular act. Canon 2272 Covenant or covenant clause may also be validly used to define individual promises on conveyance evidences or other instruments pertaining to real property within the covenant. Canon 2273 excluding the sacred covenant pactum de singularis caelum, a covenant clause is broken by any single omission of duty or any act that contravenes the provisions of the agreement entered into between the parties. A covenant therefore is broken, extinguished and ceases to have effect when all its clauses have been demonstrated to have been broken. Canon 2274 The benefit of a covenant that runs with the land descends to the heirs, and they as well as devisees of the covenantee are entitled to enforce such a covenant. However, if the covenant is personal, it remains with the covenantee, or his executor or administrator, and does not descend to the heirs. Canon 2275 A covenant is extinguished when the trust corpus ceases, or when the covenant and the trust corpus becomes vested in one person. Article 129 Charter Canon 2276 A charter is a formal and official instrument of importance issued by a competent authority of a Eucadian society either as a deed, a map or tablet. Canon 2277 An instrument is not a valid charter but an inferior or false document if it is not issued by a competent authority of a Eucadian society in accordance with these canons. Canon 2278 In accordance with these canons, as a deed, a valid charter is constructed of three essential elements: a beginning known as the inceptum, a body known as the decretum, and an official sealing known as the obsignatum. Canon 2279 The first element of a valid charter is called the beginning, or inceptum. It may be a single sentence if a single large sheet of paper, or a combination of elements including a title page, preamble and index if a valid charter defined over several pages. Canon 2280 The second element of a valid charter is called the enactment, or decretum. It may be a series of clauses if a single large sheet of paper, or several pages of articles if a valid charter defined over several pages. Canon 2281 The third element of a valid charter is called the seal, or obsignatum. The obsignatum signifies by what authority the charter has been decreed, and may be a raised or bound seal if a single large sheet of paper, or a printed seal if a valid charter defined over several pages. Canon 2282 A valid charter as a deed may be in one of two forms: a single continuous large sheet called a concordat, or printed on standard-sized paper on several pages bound together in a folio called a codex. Canon 2283 A concordat or concordant by name or design is invalid unless it is a valid charter conforming to the standards described by these canons. Therefore any documents called concordat or concordant that do not conform to these canons are henceforth null and void from the beginning. Canon 2284 A charter is invalid if written upon the skin of any animal, vellum, parchment of any kind is strictly forbidden and automatically renders any such instrument null and void. Only ecclesiastical deed poll is permitted to use the flesh of a living being, namely the blood of the true trustee of the true person who seals it with his or her thumbprint. Canon 2285 A valid charter may contain an Eucadian time element at the end of the enactment known as decretum and before the obsignatum. However, the words date, day may never be used as part of the time, as such words are defective. If such words are used, they shall have no material effect and imply nothing. Article 130 Bidding Canon 2286 Bidding is the process of reaching an agreement through the process of offering a good, service or security for sale and then securing its sale to the highest bidder, usually through a formal process such as an auction. Bidding is in effect the formalization of the ancient art of haggling. Canon 2287 The word auction is derived from the Latin word auctiones, meaning a sale of slaves through a bidding process. The special register of slaves or tabulae was even called an auctionarius for such an event. The sale of bonds of slavery in honor of this ancient Roman process is continued today in Roman courts with the use of block and gavel. Canon 2288 There are generally recognized to be four common types of auction, being open ascending price, open descending price, first price, sealed bid and sealed bid, second price, Open ascending price auction, also known as an English auction, is when participants bid openly against each other with each successive accepted bid higher than the previous, and 2. Open descending price auction, also known as a Dutch auction, is when the auctioneer announces the highest asking price which is gradually lowered until some participant is willing to accept the auctioneer's price, and 3. First price sealed bid auction is when all bidders simultaneously submit sealed bids and the highest secret bid wins, and 4. Sealed bid second price auction is when all bidders simultaneously submit sealed bids and the second highest secret bid wins, and Canon 2289. As Roman courts seek to perfect the sale of bonds against the accused, the judgment also represents the opening highest price of an open descending price auction or Dutch auction with the judge or magistrate as auctioneer. Unless the accused makes a lower legitimate bid, the original highest bid, sentence, is deemed the sale price and the accused is assumed to have consented by the time the judge strikes the block with their gavel. Canon 2290. As the judgment of a Roman court is also a Dutch auction, the judge and magistrate must give adequate time for the accused or convicted to vocally lodge a competing lower bid. Should the judge or magistrate terminate the auction by striking the block prematurely and before the accused or convicted has finished speaking, then under appeal the judgment should be ruled invalid. Article 131 Deed. Canon 2291. A deed is a form possessing certain ecclesiastical authority and record of an action of conveyance that bestows or surrenders one or more rights by agreement. Hence, a deed through proper authority and action of conveyance creates valid title to use of property. Canon 2292. An instrument is not a valid deed but an inferior or false document if it is not issued in accordance with these canons. All conveyances of rights must be perfected through a valid deed. Canon 2293. As all ownership of property is ultimately derived from the divine creator, a valid deed always possesses the appropriate level of ecclesiastical authority representing either an approved action permitted by divine law or specifically approved by an ecclesiastical representative in accordance with these canons. Canon 2294. In accordance with these canons, a valid deed is constructed of four essential elements: a preamble known as the exordium, a recital of aims known as the recitatum, a body of clauses to the agreement known as the pactum, and an official enactment of the agreement by seal or signature at the end known as the decretum. Canon 2295. The first element of a valid deed is called the preamble, or exordium. It may be a single sentence known as an inceptum if a single large sheet of paper, or a combination of elements including a title page, preamble and index if a valid deed defined over several pages. Canon 2296. The second element of a valid deed is called the recitals, or recitatum, outlining the purpose of the deed. It may be encompassed by the inceptum if a single large sheet of paper or one or more pages long if a valid deed defined over several pages. Canon 2297. A function of the recitals or recitatum of a valid deed is to clearly describe the grantor's intention and motives for their deed, the names, designations and descriptions of the parties, the consideration expressed for the deed, words of grant and the description of the property conveyed. Therefore, it is in the recitatum of a valid deed that property is effectively granted. Canon 2298. Words of grant are such words as grant, convey, assign, set over, transfer and give, and are indicative of the intent to presently pass title. The absence of valid words of conveyance within the recitatum of a deed void the deed. Canon 2299. The third element of a valid deed is called the agreement, or pactum, outlining the terms of the deed. It may be encompassed by the decretum in a single large sheet of paper or several distinct pages of clauses as a valid deed defined over several pages. Canon 2300. A function of the agreement or decretum is to clearly describe the conditions upon which the property is granted, their warranty and other covenants of title, and the covenants relating to the use and enjoyment of the property. Canon 2301. The fourth element of a valid deed is called the enactment, or decretum representing the enactment or execution condition of the deed. If the valid deed is a single large sheet of paper, then the decretum may also contain an official seal known as the obsignatum. Canon 2302. A valid deed may be in one of two forms: a single continuous large sheet called a concordat, or printed on standard-sized paper on several pages bound together in a folio called a codex. Canon 2303. A valid deed may contain an Eucadian time element at the end of the agreement known as the pactum and before the decretum. However, the words date, day may never be used as part of the time, as such words are defective. If such words are used, they shall have no material effect and imply nothing. Canon 2304. A deed is invalid if written upon the skin of any animal. Vellum, parchment of any kind is strictly forbidden and automatically renders any such instrument null and void. Only ecclesiastical deeds and pronouncements are permitted to use the flesh of a living being, namely the blood of the true trustee of the true person who seals it with their thumbprint. Canon 2305. A deed poll is a valid form of deed, sealed by a thumbprint signature whereby a person first expresses, affirms and conveys certain rights to another party who are then lawfully bound upon consent by silence, proof of receipt or service. The word poll comes from the Latin pollex, meaning thumb. An ecclesiastical deed poll is the highest form of valid deed. Canon 2306. An indenture is a form of deed, named after the tradition of its making, whereby duplicate copies of the same contract were produced and then separated by a unique jagged or toothed cut so that the two parts could be retained by separate parties and rejoined at any time for confirmation of authenticity. Canon 2307. A valid deed poll given by one party and accepted by another is as effectual as if a formal indenture had been signed by both parties. Canon 2308. A lease is a valid form of deed whereby right of use known as equitable title is conveyed, never ownership of right of use known as legal title. Article 132. Will. Canon 2309. A will or testament is a form of deed by which a person, known as the testator, names one or more persons to manage their estate and provides for the transfer of the property at their death to one or more beneficiaries. Canon 2310. A will operates only upon and by reason of the death of the maker. During their lifetime it is changeable and revocable. At the death of the testator, a testament is traditionally considered irrevocable and unchangeable. Canon 2311. At the death of a testator, a valid will or testament acts as the deed in formation of a testamentary trust with all property of the testator named by the deed conveyed into the trust corpus, also known as the estate. Canon 2312. A will cannot name or imply an heir, but beneficiary. The existence of a will clearly and unambiguously expresses the intent to disinherit an heir of one or more rights of inheritance. Canon 2313. Beneficiaries of a will may be identified in only one of two ways: by explicit name, or by implied succession to the testators. Canon 2314. When a beneficiary is named in a will, the rights of the particular beneficiary ceases upon the death of the named person, with associated rights reverting to the executors and administrators. Canon 2315. When a beneficiary is implied by succession in a will, the rights of the particular beneficiary or beneficiaries continue for the life of the estate and the continued existence of a living person fulfilling the lawful description of a beneficiary. Canon 2316. The will for a large estate with many beneficiaries is called a constitution. Most constitutions identify beneficiaries of the deed and will, constitution, by implication of succession, such as the United States. Canon 2317. An amended will is called a codicil. A codicil can only be created whilst the testator is living and before the creation of the testamentary trust. If a codicil is clearly inconsistent with the will, it operates as revocation of the will to the extent of the inconsistency. Canon 2318. As a will as deed of a testamentary trust is essentially irrevocable and given the former owner as testator is dead, and then in theory the estate, also known as the trust corpus, and dead, body corporate and also corporation can continue forever. Canon 2319. The deliberate fraud by alteration of a will to a testamentary trust is the most grievous act an inferior Roman official can do under inferior Roman law, as all nations under Roman law operate as deceased estates. If uncorrected, such an error is an open admission that all Roman law has ceased to exist and is therefore null and void. Canon 2320. The deliberate concealment and withholding of beneficial entitlements to a beneficiary of a testamentary trust in accordance with its will is a serious fraud, negating any and all obligations, debts and sureties of the person denied their entitlements. Article 133 Ecclesiastical Deed Poll. Canon 2321. An ecclesiastical deed poll is a valid form of deed poll and therefore deed and contract whereby a true person first expresses, affirms and conveys certain rights to another party who are then lawfully bound upon proof of receipt. The word poll comes from the Latin pollex, meaning thumb. Hence a historically valid deed poll is one sealed by a thumbprint. Canon 2322. An ecclesiastical deed poll is primarily different from a standard deed poll in that a true person evokes their divine rights conveyed on robin egg blue, sky blue, light blue paper and sealed by a thumbprint to a Roman person who has sought to usurp or abrogate these rights, such as the executive officials of a nation that administers their slave rolls, also known as register, from which the Sestuecavi trusts are born. Canon 2323. An ecclesiastical deed poll is permitted to be issued when a man or woman seeks to be free of the Roman slavery system by serving national officials that control the registration process through departments known as vital statistics or births, deaths and marriages. Canon 2324. Only a true person may issue an ecclesiastical deed poll. By definition, a man or woman acting in the capacity of being an inferior Roman person has no authority to issue an ecclesiastical deed poll. Canon 2325. An ecclesiastical deed poll must always be on standard, legal/A4, sized robin egg blue, sky blue, pastel-colored paper, printed in serif Times Roman, Garamond, font, in recognition and respect of its status as a divine notice with the full authority of one heaven. Canon 2326. Prior to UK 8:Y 3200-10:A35:S3:M12:D4, also known as Sun, the 12th of June 2011, also known as the Day of Divine Illumination. A valid ecclesiastical deed poll must always be sealed in the blood of the trustee of the true trust issuing it by using their thumbprint with the blood signature covered by clear plastic or tape from direct exposure. Thereafter, this time, only ink is permitted as the medium for sealing. The reason for the blood seal prior to the Day of Divine Judgment is, I. The root of all Western law originates from the root of ancient laws of civilization and law of ancient Sumeria, Assyria, Israelites, Celts, Greeks and Romans that recognized blood as the most sacred seal of instruments in honor of the most ancient blood covenant with the divine being, the covenant of Mithra, and 2. In accordance with the most sacred covenant Pactum de Singularis Caelum, all historic and ancient covenants of the divine are fulfilled with the covenant of Mithra, which ended upon the Day of Divine Illumination. Therefore, the blood seal is a historic symbol of the conveyance of law from those who are in dishonor to those who now represent the true living law. And 3. The blood of the trustee of the true trust and the content of the ecclesiastical deed poll prove the fraud and error of the continued existence of any Sestuecavi trust in assuming the body is dead, and 4. The infusing of the blood of the trustee onto the paper breathes life into the paper, creating an instrument superior in standing than even an inferior Roman papal bull. Therefore, if the document is dishonored, then all documents ever issued by any society under Roman law must also by definition be null and void, and the use of blood in this manner perfects an unbreakable seal of an unbreakable deed and contract. Therefore, any inferior Roman court that usurps it openly admits that contract law under inferior Roman law no longer exists and that all authority has been conveyed to the society of one heaven, and When inferior Roman officials dishonor such a sacred deed, they dishonor the root of their own law, and therefore they officially validate the lawful conveyance of all property, rights and standing from themselves to those who stand as members under the sacred covenant Pactum de Singularis Caelum. Canon 2327. When an ecclesiastical deed poll is issued, it is under the Supreme Court of one heaven with the full authority of the Divine Creator and all inferior courts including the Sacred Rota and the Divine Sanhedrin. Hence the term per curiam divino is always included to make clear to the inferior Roman person the absolute authority of the instrument. Canon 2328. While a true person issues an ecclesiastical deed poll, it is ultimately a divine notice of protest and dishonor from the Divine Creator. Therefore, the dishonor of an ecclesiastical deed poll is the most grievous injury of the law and blasphemy to all believed to be divine. Canon 2329. When an ecclesiastical deed poll is dishonored by a representative of Roman law, Sharia law or Talmudic law, it is public notice by all officials of those religions and systems that they do not believe in the divine and that all their law is by definition null and void. Canon 2330. When a Roman slave under inferior Roman law repudiates a valid ecclesiastical deed poll, then by definition all acts undertaken with the assumed authority of Sacred Rota by any registrar, keeper of rolls, clerk, protonotary, plenipotentiary or minister are null and void, including and not limited to any warrants, summons, orders, decrees. Canon 2331. An ecclesiastical deed poll must always be on standard-sized legal/A4 Robineg blue paper and glued strongly to the reverse back of a certified copy of a birth certificate, preferably in long form, or if not possible to obtain, then in standard, short form. Canon 2332. A valid ecclesiastical deed poll should conform to the following words, with any bracketed text, including the brackets, removed and replaced with the personalized information. Ecclesiastical deed poll. Per curiam divinovi, the divine immortal spirit, expressed in trust, to the circumscribed living flesh known as first name, middle name, surname, have hereby given life and personality to the following memorial and record of event through our sacred irrevocable deed of ancient valid form sealed by sacred pollex and agreement to the conveyance and terms pronounced herein. 1. First, we did annex hereto in full our pronouncement of restitution, and 2. Second, we did annex hereto in full the sacred treasury remittance of our live-born record and certificate of title from the Great Register and public record of one heaven as proof of superior title against any other claimed title and record, and 3. Third, we did pray and confess as an act of true contrition our genuine remorse and penance for any unresolved debts, liens or other financial encumbrances that previously prevented the lawful annulment of any records of events on your rolls and registers associated with us and our ancestral bloodline of children, parents, brothers, sisters, cousins, grandparents, great-grandparents and great-great-grandparents, as restitution, just as the Divine Creator has absolved us and forgiven all our debts. We and our immediate bloodline received absolution and acceptance of our payment in full through our solemn remittance from the treasury of one heaven by our sacred sacrifice and seal. And 4. Therefore, upon all debts and encumbrances concerning us and our immediate bloodline being fully settled, with no possible legitimate claim or objection remaining, we demanded upon your fiduciary duties and oath of office that you did annul from the beginning any and all record of events and claims from your records against us and all our ancestral bloodline, including but not limited to our name, flesh, spirit, and 5. Furthermore, we demanded any and all temporary testamentary trust, cestuecavian or derivative thereof formed upon such mistaken entries into the public record were immediately dissolved, including a full account provided to us within 7 days, and 6. Notice is given that all acts in commerce or law we engage as surety of our trust number 1234561234561234556 and request all original records previously associated with your claims are returned to us cancelled and signed as evidence you have complied with your duties and oath of office, and 7. As we had given proper notice, you acknowledge that no further demands, debts or actions shall be issued against us, and any charges sent to us by mistake will be duly returned to you for immediate discharge in accordance with the law. Ink seal of witness 1, thumbprint in ink. Ink seal of witness 2, first witness, second witness. 2. Name of official, care of, address and details of official. Canon 2333. No date or time is permitted to be written onto an ecclesiastical deed poll as it is issued from the divine from the beginning. Canon 2334. No signature on an ecclesiastical deed poll is permitted by the true person, as a signature is a sign of a Roman slave. Furthermore, the definition of poll in the context of a deed poll means thumbprint. If a signature is included by the true person by mistake, it shall have no material effect. Canon 2335. No registration sticker or mark is permitted to be pasted onto the ecclesiastical deed poll, as proof of delivery is sufficient for the deed to be validly executed. Canon 2336. No bolding or underlining of words is permitted, nor the editing of words except the replacement of words indicated in brackets, including the brackets themselves. Canon 2337. No reference to these canons, 1 Heaven or Euchadia, are required on an ecclesiastical deed poll, as the instrument is between a true person, the divine creator, and the official of the inferior juridic person who dares defy and usurp their own laws. Article 134 Constitution. Canon 2338. A constitution is a particular form of deed of and temporary testamentary trust, also known as a sestuique, vi. Trust, forming a trust corpus, also known as a body corporate and estate, and therefore corporate personality, administered by executors and their administrators for the heirs and beneficiaries of the estate. The word is derived from two Latin words, con, meaning with, together, and statua, meaning decree, statute or judgment. Canon 2339. Constitutions may be distinguished from statutes that also create sestuique, vi. trusts by several significant factors. The executors, as executives of an estate formed by constitution, are typically appointed by a vote, or by a general election and vote by the beneficiaries and then endorsed by the trustees. And 2. The size of the estates formed by constitution can be extremely large, sometimes covering tens of thousands of miles of land and attached chattel, immovables and other property. And 3. The number of beneficiaries of the estate formed by constitution can also be extremely large, sometimes involving tens of millions of men and women. And 4. Beneficiaries are lawfully entitled to their benefits under a will. Therefore the executors and administrators must issue some certificate of share entitlement to each beneficiary. This occurs, but is deliberately circumvented by using the trickery of sestuique, vi. trusts, and v. the true legal personality. Structure and operation of estates formed by constitution are hidden from the beneficiaries in direct contradiction to the principles and terms of valid consent under any benefits granted by will. Canon 2340. An estate cannot exist without a sestuique, vi. trust. A sestuique, vi. trust cannot exist and function without a functioning deed and will via statute or constitution. Therefore any state or nation registered or operating as a corporation or corporate personality must by definition belong to an estate guided by a functioning deed and will. Constitution. Canon 2341. As a constitution is the deed of a sestuique vi trust, a person can never be an heir to it, only a beneficiary. Article 135. Lease. Canon 2342. A lease is a form of deed granting use of property during a specified period in exchange for a specified rent. The one who grants the lease is called a lessor, while the one who is granted limited rights of use is called the lessee. Canon 2343. A lease is equivalent to equitable title of ownership, whereby a person may be granted rights of use and rights of occupancy, but never legal title. Canon 2344. While there exist many forms of valid leases, all leases share the following elements: I. The names of the parties, and 2. The starting day and duration of the agreement, and 3. The specific property being leased, and 4. Conditions for renewal or non-renewal of lease, and v. consideration such as a lump sum or periodic payment, rent, for granting use, and vi. provision for any surety deposit and terms of its return, and 7. default conditions and remedies for any breach, and 8. specific conditions particular to the type of property such as insurance, restrictive use. Canon 2345 lease may be fixed term, periodic or at will. Canon 2346 the highest form of property granted under lease is equitable title of real estate, never real property. Real estate implies the highest right of use in a particular estate, while real property means first right of use above all others. Canon 2347 lease and equitable title are equivalent in that most equitable title is granted under lease. All mortgages are forms of lease and equitable title. Canon 2348 while the terms title of ownership and ownership of equitable title are frequently and deliberately used to deceive and defraud leaseholders into believing they hold accruing rights of ownership, there is no purchase of legal title with leases. Canon 2349 right of redemption is the right of the tenant holding a lease for a reasonable period of time to make good any arrears in rent, without eviction, or even after dispossession make good any arrears and lawfully re-obtain possession of the property. Canon 2350 it is unlawful to include any clause on a lease or mortgage that claims a waiver of right of redemption. Article 136 Negotiable Instrument Canon 2351 a negotiable instrument is a form of deed and title of a temporary trust granting the valid holder either equitable or legal title to a form of property based on an agreement by another party to make an unconditional promise or order for payment of a fixed amount of currency and any charges to a third party by a fixed time or on demand in the future. As the valid holder may then sell or buy and convey title of this deed without its alteration, it is called a negotiable instrument. Canon 2352 an instrument is not a valid negotiable instrument but an inferior or false document if it is not issued in accordance to these canons. Canon 2353 excluding certain limits of disclosure permitted for lawful currency. A valid holder is a person who can prove a lawful conveyance of the instrument to them through such a transaction being registered in a great register and public record of a valid Eucadian society, including the provenance being history of all previous conveyances for the existence of the instrument. Canon 2354 excluding certain limits of disclosure permitted for lawful currency. A person who is unable to prove lawful conveyance of a negotiable instrument to them is not entitled to be regarded as the holder or bearer, even if their name is listed on the physical document. Canon 2355 a negotiable instrument depends upon the existence of a temporary trust relationship. The length of existence of the trust is dependent upon the length of time the property remains in trust before being conveyed either at a fixed maturity date, or upon being redeemed upon demand. Canon 2356 any statute, code or ordinance that claims to govern the function of negotiable instruments yet conceals or does not mention the implicit importance of the temporary trust personality of negotiable instruments is fraud. Therefore, any instruments created by such statutes, codes or ordinances are founded on fraud. Canon 2357 all valid negotiable instruments issued in accordance with these canons have the following essential characteristics. I. The promise or order to pay must be unconditional, and 2. The payment must be a specific sum of money, although additional charges may be added to the sum on conditions, and 3. Any form of interest calculation, also known as usury, is strictly forbidden, and 4. The payment must be made on demand or at a definite time in the future, and v. The instrument must not require the person promising payment to perform any act other than paying the money specified, and vi. The instrument must be payable to bearer or to order. Canon 2358 when the holder of legal title of a negotiable instrument sells equitable title to another, the payment for tenancy and use shall be property called rent and not interest. Canon 2359 all currency issued using property as underwriting is as negotiable instruments. Canon 2360 any bank, treasury or financial institution that deliberately conceals payments under equitable title as interest or some other description instead of rent is guilty of gross fraud and immediately loses the right of legal title over any and all instruments committed through fraud. Canon 2361. When any bank, Reserve Bank or Treasury deliberately conceals the issuing of currency and payments under equitable title as interest or some other description instead of rent, consents by such fraud and concealment against the people that all liability shall be personally returned to the ultimate owners of the bank, then all leases shall be cancelled and all legal and equitable title shall be forfeited, including the right to remain as a central bank. Canon 2362. The two primary forms of negotiable instruments are drafts and notes. A draft is an instrument that orders a payment to be made at some future fixed date or on demand. A note is an instrument that promises a payment will be made at some future fixed date or on demand. Canon 2363. When a valid draft, negotiable instrument, is created, the person who is ordered to make payment is called the drawee and the person who signs or is identified as the one ordering the payment is called the drawer. When a drawee accepts a draft they are then called the acceptor. Canon 2364. When a valid note, negotiable instrument, is created, the person who signs or is identified as the one promising to pay is called the maker, also known as the payer, and the person who is identified as receiving the payment is called the payee, or holder, known as the bearer.